So we're going to deal today with a subcategory of the duty of loyalty, really a small doctrine. We have two little cases here to talk about the corporate opportunity doctrine. And the corporate opportunity doctrine deals with when a director doesn't only stand on both sides of a transaction, but this also deals with potential transactions that are in the line of business or in the expectancy of a corporation. So obviously when you're a director, you get wind of a lot of deals. You might have access to certain, to know that there are certain opportunities that come up to buy companies, to buy land, to buy things that your company might otherwise want for itself. And so this creates an obvious duty of loyalty conflict because the person stands to benefit themselves from a transaction. And we don't actually completely exclude this because directors by their nature are not full-time employees of a company. They often have their own businesses to run. They have their own concerns and considerations. So it's not necessarily, as we saw with duty of loyalty, going to be a breach if a party is not able to, if a party does have an interest in something that the corporation has an interest in, but we're going to need to go through a similar kind of cleansing process. So we're going to talk about the tests that are applied under the corporate opportunity doctrine and look at a couple cases that sort of set the stage. So we're going to start with a traditional case. And the traditional case stands for the baseline principle. As you've seen, by the way, the duty of care, as time has progressed, has become less important. It has become less of a stick for shareholders. We're going to find that over time, courts have more and more protected directors when they're making business decisions, understanding that the essential role of directors is to make those decisions. On the other hand, courts have become more favorable to hearing breach of loyalty claims. And so we see an increase in that department. So the traditional approach forbids a director from diverting a business opportunity to themselves when it belongs to the corporation and requires a finding of actual harm. The actual harm part is what made that doctrine so hard, and what we'll see as we talk about the modern application is that we don't have to show actual harm under the elements of the modern corporate opportunity doctrine test, right? We don't have that element of harm. But inherent in this definition are some definitions itself. So what are some terms we might want to define in order to figure out when a director has diverted a business opportunity? Right? There's a key definition here, right? We have to understand what is a business opportunity. If we don't know what a business opportunity is, we can't tell when it belongs to the corporation. So we'll have a test for that coming up. So what happened in the case of Guth v. Loft? So Charles Guth ran a candy store. And this was a candy store that had a soda fountain. I think they were called pharmacies kind of in the 1950s. I'm picturing Back to the Future Part 1. Where he goes in and gets his milkshake, where his mortal enemy Biff Tannen comes in, right? So he's at the pharmacy, he's at the candy store, and he wants to get Coca-Cola machines. And Coca-Cola, at the time, refused to give him a volume discount. It said, you're not a big enough store for me to care about. I'm not going to provide that discount for you. And so Guth decided that he was going to buy Pepsi-Cola, which was in bankruptcy at the time, wasn't competing very well. He changed the formula and served it at his at Loft. Now, who is this Guth? He is a director. He was running Loft Inc., but Loft has other shareholders. And so the question is going to be, was the acquisition of PepsiCo a corporate opportunity for the candy store, for Loft Inc.? If it was, then he took it for himself. But obviously, he might have felt that this was an opportunity that was just for him. So how do we resolve this issue here? So getting to the the issue again, did Guth divert a corporate opportunity to himself in this case? And the facts, as I'm painting them, really are quite simple. I have the case online for a little more of the detail. But we have a company that runs a pharmacy or a candy shop which has soda fountains, and he purchases a soda manufacturer. Right? So is this a corporate opportunity? Is the acquisition of PepsiCo a corporate opportunity for Loft? What do you think, Justin?
I would say yes.
Say yes. Why? Why is that in the... What kind of test might the court apply here to see if this is within there, if this is a corporate opportunity?
Is there a line of business test?
Yes, this is, if you think about lines of business, people talk even about upstream, downstream suppliers, purchasers. So right now this is an upstream supplier. So it's literally, if you, well, figuratively, I guess, but figuratively in that line of business. So this is one place that they obtain materials for, and so a company is presumptively always thinking about whether they're going to, we learned about this in talking about the theory of the firm, right? Whether a company wants to take things on and do it internally or contract out. So it's inherently within a corporate opportunity when you're going to an upstream supplier or downstream purchaser, because those are contract relationships the corporation already has. Those are pre-existing relationships. Maybe it wants to revise those relationships, structure them a little differently, and provide that, that way the store could have access to this Pepsi. And yes, in fact, that's exactly what happened. Guth here was found guilty of usurping a corporate opportunity. And we'll use that term, usurp, to specify that we're dealing with a corporate opportunity. So kind of a little buzzword or keyword to help you remember the doctrine, because it's unusual in common parlance. Yeah, so what was the reason here? Well, this was an unlawful usurpation because the manager took an opportunity for himself without offering it to the corporation. And again, how do we define opportunity? We're going to see the first definition of that here. An opportunity is if it's one the corporation can financially undertake. Right, so this would matter if Loft was very small and only had 1 or 2 stores, and although it did purchase Pepsi, it would not have been able to purchase PepsiCo, right? Then it would not have been a corporate opportunity, because a corporate opportunity is not speculative. It has to be something reasonable. Drew?
Now, if Guth would have had like the financial ability to do this himself, do you think it was still working out the same way?
If Guth did do it, wait.
Well, because it said it indicated he used Loft's money to fund a lot of it.
Oh, yeah, that's definitely right. I think it would still have come out the same way. Yes, yes. Under the simpler facts, where this was simply in the line of opportunity, yes. There, he also was then stealing from the till, which is an additional fact which we don't even need to get to this result.
Okay.
Yeah, Joe.
But why would it be, even if it was just him using his own money, do you think would still? Because that doesn't seem to smack of interference with corporate. If it's not his money, not the corporate money, and it's not something that I know it's upstream, but it's not directly in conflict with it. How could that be?
Why is that a corporate opportunity? Well, here the court is presuming that because there is an existing contractual relationship between Loft and Pepsi, right? They're a purchaser of Pepsi. That's an upstream supplier. And according to the theory of the firm, companies will decide whether to contract relationships out or grow larger and encompass that function, depending on various market factors. And so this is presumptively within that scope, because a company will often think about purchasing an upstream supplier, right? In fact, there was just an article yesterday that Apple, I think, was going to start purchasing or mining its own magnesium, right? It's having difficulty in obtaining magnesium. So would you think that magnesium mining is part of Apple's line of business, right? That was clearly turned out to be within their line of business. And why is that? Because they're in the business of at least obtaining magnesium. The fact that they're obtaining it through contracts versus obtaining it through their internal structure shows, in fact, that that is definitely part of their business. And here it's indicated by the fact they did, in fact, purchase a magnesium producer. I think it was magnesium. It was one of those earth metals, semi-rare earth metal that they need for their whatever. But obviously you think of Apple as a technology company. To a certain extent, they're a hardware company. They're definitely a software company. You don't think of them as a magnesium company, but they're within that line of business. And Apple has a ton of money, so it's something that it could financially undertake, right? So, the fact that Loft had the money for it, if Guth didn't take it, it also goes to the fact that Loft had the financial ability to do it. Would it have been advantageous to the corporation? That's hard to prove with 20/20 hindsight, but it looks like it was, because Loft failed and Pepsi succeeded. Maybe it failed because it didn't have the trendy soda that everyone was drinking these days, those kids. What was the reasonable expectancy? I think the best way to think about that is you clearly have a reasonable expectancy if there's already an existing contractual relationship. And just to reiterate what I said earlier, that goes back to the concept of the theory of the firm, where a corporation might decide to contract out and stay small, or to grow larger, depending on that relationship between the expense of doing something internally, the expense of doing it externally, risk and other factors. So they would probably find that if a director of Apple purchased a magnesium mine for themselves, that may not sound like much, but look, Apple did in fact do that. So the broadness of this should be impressive at this point. You should recognize that this is a broad doctrine, and as I mentioned, this is going to get broader. So unlike the duty of care, where we're thinking narrow, shrinking it, a lot of protection for directors, we don't want to protect directors from shirking. We don't want to protect directors from stealing. We don't want to protect directors from taking usurping opportunities. That doesn't have any social function, right? What is the social function of director? To take business risks, to make business decisions. So we want to protect their ability to do that, and the duty of care has been circumscribed. The business judgment rule, exculpation, indemnification, insurance, those are all ways that we can really reinforce the notion that when directors act with paper and process, we assume they're doing so in the best interest of the corporation because we want them to do that. That is their function. That's why we hire them. We want to protect that function as much as we can. That's their social benefit. That's how they add value, is choosing the direction of the corporation. That's what shareholders don't want to do. But what do shareholders also not want to do? They don't want to be monitoring their directors constantly for fear that they will be stealing from them. There's no social function in a director stealing from a corporation. And so the duties of loyalty come in when a director stands on both sides or potentially interferes with a corporate opportunity. It's essentially stealing an opportunity. And so we're going to define that very broadly, as we'll see more in our next case of Servan Land. So what happened in Servan Land? In Servan Land, we have a golf company, a golf course, and it had built a golf course on 180 acres, which was a sizable parcel of land down in Florida. And in addition, there was a third party, Farquhar, I believe is how it's pronounced, Farquhar, who offered to sell them an adjoining 100-acre parcel. Right, so, I know, it's cute, right? Just gonna put that up there sometimes. So, going with the same notion here, now that we saw how broad this corporate opportunity doctrine is, do you think that this golf course owns 180 acres of land? Land is a fundamental feature of a golf course. You cannot operate a golf course, obviously, without land. I don't golf very much, but I'm pretty sure that you can't do it on an acre very well, right? You need to hit the ball. I mean, I can't hit it 400 yards, but some people can, and so you need to be at least that big times 18 holes. So, is it a corporate opportunity to purchase more land next to the golf course you have? What could a corporate, does that seem like a corporate opportunity? Yeah, it clearly does. This is clearly in the scope of a corporate opportunity. This is what can a golf course do with more land? It could build more course. Right? It could offer additional holes. Some golf clubs, I lived in Florida, and there's a lot of people who golf down there, and they might select where they purchase a home because they want to have access to a variety of places to golf. So this could be very valuable. And so we're clearly in the range of this being a corporate opportunity, but that doesn't necessarily make it bad. What happened next was more problematic. So what happens here? Well, Servan and Servini and Savin were directors and majority shareholders, and so they can control a lot of the shots. They still owe duties to their other counterparts, and so they decide to bring this to the shareholders. And they actually give the shareholders the opportunity to purchase this, and the shareholders do not do that at a meeting. And within a year, Servan and Savini bought the land for themselves. So 4 years later, they sold the golf course as a package deal for $8.3 million, and Servan and Savini themselves took 3 1/3 of that. So we have a suit here. We have a suit that this $3.3 million parcel, or at least the profit on it, right? That would be the amount of harm that the company would have earned had it purchased and sold that land. Does that flow to Servan, Serani, and Savin, or does that flow to the company? So what did the court hold? Did the court hold that there was a breach of the duty of loyalty here? Was there a breach here under these facts? Was there a breach of the duty? Right? Did they take a corporate opportunity in purchasing this tract? Yeah.
They said that they didn't in this court because it didn't constitute a corporate opportunity. The additional property had no substantial relationship to the golf course and its primary purpose.
I don't think that's how the appellate court came out, actually. In fact, anyone have a different? Maybe that was the trial court. Ian.
Oh, I'm sorry.
Yeah.
I'm behind you.
It's okay.
Yeah, so that's what obviously the trial court said. And then they started to go through it at the appellate level and said that there was a corporate opportunity was designed to do.
So what are the steps the court goes through in evaluating this? There are sort of 4 separate issues that are discussed in the process of evaluating whether or not there is an actual breach. I mean, just like with torts, you don't get to breach, you don't get to negligence just by a duty. Yeah.
They asked whether a corporate opportunity existed, whether the stockholders declined the opportunity by failing to act, whether the stockholders ratified Servan Land purchase, and whether the subsequent benefit the corporation received in selling its assets in conjunction with it rectified any wrong.
Great, because we have to get to harm, and we've kind of got, if you want to just put it in kind of your negligence framework, right, we've kind of have the duty breach, cause and damages type of elements here. So on the first part, as Lee pointed out, we have to first find there's a corporate opportunity, right? That is sort of similar to saying there was a duty. There's no duty of loyalty problem if this is not within the corporate opportunity. And again, we're going to define corporate opportunity very broadly, because we don't have any social value from directors usurping these opportunities and stealing from their companies. And so there has to be a valid and significant purpose, but we're going to find that frequently. Then we're going to ask whether the shareholders declined that opportunity. And just like we learned in shareholder ratification, as we learned from, sorry, blanked on the case. Sorry, I was way back there. Shareholder ratification is only valid if it's informed, just like director ratification is only valid if it is informed. And so I can picture in the image of it, and I'll come back to it in the review, but that picture I showed you and told you shareholders are sheep. I mean, they had a meeting to approve the acquisition. This is Van Gorkum. That the Van Gorkum the one that he had selling TransUnion, they approved the transaction, but they did it without information about what the company was worth. So we're going to have the same process here, where the shareholders have to approve the transaction when they're informed. So they have to have that affirmative ratification, informed ratification, or informed declining of the opportunity. And then finally, kind of like with negligence, we don't actually have a claim if there's no harm. And so likewise here, if the company was not going to make any money from the deal, there would not be an issue. Now, we don't have to show actual harm like we did in Guth v. Loft. We just have to show potential for harm. And here we actually had actual harm. So let's take a look at how that analysis plays out in this case. Right, so again, we have a golf course sitting on 180 acres. The discussion is about selling the parcel next to it. This is clearly a corporate opportunity. It's absolutely a corporate opportunity. Golf courses are in the business of having land, and it would be a valid and significant purpose of buying the adjacent property. They could use it to build more golf course, which is their business, their main of their business. So there's really not a big issue there. The shareholders, they said, the appellate court held that the shareholders did not reject this. And quote from the court on that first point, the opportunity to acquire the Farquhar land was an advantageous one that fit into a present significant corporate purpose, as well as an ongoing corporate policy. And the corporation had an active interest in it. Accordingly, the opportunity to buy the land constituted a corporate opportunity. Now, that's a very easy case. Now, whether or not purchasing a technology company purchasing an upstream supplier is slightly harder, but I think it's safe to say that if you're in a contract relation, if a corporation is in a contract relationship with a party, it's fair game for that to be a corporate opportunity. It really looks bad if a director disrupts a contract relationship. And then, of course, if a director purchases an upstream supplier, such as what happened in Guth, right now the director stands on both sides every single time that company buys Pepsi. And he may not be looking to give them a volume discount either. So our second element, did the shareholders reject it? No, they didn't have enough information about the land to reject it. That's a factual finding. We're going to take the trial court at face value there, right? The appellate court says there was not enough information. Similarly, they did not ratify the transaction because they didn't have sufficient information to ratify. A ratification is only valid so much as that it's informed. And since S&S were making these assertions based on their own personal interest in getting the land, they were not necessarily telling the whole story. This kind of smells a little bit like Van Gorkum, where he really wanted to get the deal done, so he probably wanted to put some cash in his pocket before he walked out the door. He didn't want to hold a bunch of securities with a lockup period. He'd much rather have a fat stack of cash for his early age 62 retirement. And similarly here, S&S, they're on both sides. So we can't trust Van Gorkum in the Van Gorkum case. We don't trust S&S in this case. Their information they're providing is not necessarily going to cleanse the transaction. And finally, this was a large profit, this sale. They made quite a bit of money on it. And so as a result of it, we're going to find again that we have a violation. And the court said, to this point, if a corporate opportunity existed, the corporation and its stockholders would have been entitled to profits from the sale of both parcels. And now they're only receiving the sale from one parcel. Plus, it's hard to divide the value of each parcel. Why was one parcel valued at 3.3 and the other at 5? Right? It seemed like it was cut based on 180 acres, 100 acres, like kind of just doing the math. But maybe one parcel was better than the other. Maybe this new parcel was better or was improved by the fact that it was contiguous with the rest of the course. And so the shareholders here are going to be entitled to those profits. And what's the remedy? The remedy is that the directors will be held, have to hold the profits in trust for the corporation, right? They were trustees, and now those profits are held by them as trustees. And so we have a couple tests that come out of this, right? So what are those tests? Those tests are whether or not, to determine whether or not something is a corporate opportunity. And I'll go over this again in the review in just a minute. We have the interest or expectancy test. Oh, I've got my slide for this here. I was feeling the gist today. We have our corporate opportunity test, our interest or expectancy test, right, which is whether or not it's within the interest or expectancy of the corporation. The line of business, right, is it the same line of business? Is it upstream or downstream of our line of business? Is it our next adjacent business? Economic capacity, right, whether or not the corporation had the ability to take on the opportunity. If the corporation did not have the ability. We can take a fairness test, which is whether or not it would have been fair to the corporation to take this opportunity. Now, of course, fairness is a very factual inquiry. And the corporate rejection test, did the corporation actually reject this in that case?